Judge Juan Merchan issued a new order in the Trump trial that's coming up in New York. Alvin Bragg is the prosecutor in this case. This goes back to the Stormy Daniels so-called hush money case with the perjurer Michael Cohen as the government's star witness. But we're getting very close to trial date, and so we're getting some rules now situated around the jurors. And Judge Juan Merchan, this guy right here, is presiding over this, and he has come out with a new order about the jurors and about the juror names and whether the public can hear the juror names. Now, we cannot. Now, in Arizona, this is pretty normal. We don't have juror names as part of the public record, but in New York, apparently they do, unless you're like a terrorist or a mob boss and there's potential for witness intimidation and stuff like that, or if you're Donald Trump, right? Because he's basically a terrorist, so he gets those rules as well, not the normal rules in New York. But let's talk about this with some background from the New York Times. This is from Spectrum News over in New York. From the AP, they say that Trump and his team will be able to know the names of the jurors at the upcoming trial, but the public will not. Now, jurors' names, they tell us, are typically public record, but courts sometimes allow exceptions to protect the jury, most notably in cases involving terrorism and organized crime, or Donald Trump, or when there's been prior jury tampering. So Juan Merchan, we'll read through the full order because they have some actual testimony and some excerpts from prior hearings that are interesting. But he ruled on Thursday that they are going to be anonymous, limited exceptions, only the former President Trump, only defense lawyers, prosecutors, jury consultants, and legal staff can know about these people. You understand why you might want to know the names of these people, obviously, because if somebody's a juror on the list and you're like, is that Mark Elias? Is that a blogger from Huffington Post over there? Like, who is that person over there? What are you doing there? And you want to look into their background and say, hey, that's probably not an ideal juror, even though they sit there like, I'm fair and impartial, and I'm just a lawyer, and I just work in what, you want to kind of dig into those people and look at their backgrounds. Take a look at their social media posts and the other things. There's whole teams about, who do juror research. Who are these people? And it's kind of a science, actually. So many would say that. Other attorneys would say that's all hogwash. It's just nonsense. Just pick a jury, So you never know what you're going to get. You're all kind of just rolling the dice like a casino. But the point is, so the story here goes, only Trump's lawyers and prosecutors will be allowed to know their addresses and their workplaces. Trump could risk forfeiting the names if he discloses them publicly. We'll read through what the judge said. Now, the ruling came from the prosecutors. It applies not only to the jurors seated at the trial, but also to prospective jurors who may be also summoned. Now, it stopped short, of having a fully anonymous jury, but that's what happened with Trump in the federal civil trials. And rules, of course, are a little bit different in civil trials, a little bit more strict, but federal civil trials involving the writer E. Jean Carroll. So Trump had no idea who these people were. In those trials, not even Trump nor his lawyers knew those jurors' names. So they could have had a Liz Cheney lookalike on there and they would have no idea. Juror names are typically public record, but not in this case. Now, the judge has said, however, that he has no plans to close the courtroom or for jury selection or at any other time during the trial. And this is something I've been waiting to hear about, whether we're going to have cameras in the courtroom or not. So access to the courtroom by the public and the press will not be tempered in any way, he wrote. Trump is accused in the hush money case. Michael Cohen, of course, the convicted perjurer, the guy who lied again and again and again, is going to be their key witness. And so let's jump into the opinion and the filing that came out from the judge. So, and I want to show you kind of how biased this is. This is not going to be a favorable environment for Trump at all. And you can just tell just based on the language and the structure of this filing. So the judge writes this. This is the decision and order on Alvin's motion for a protective order, regulating the disclosure of juror information, saying, coming from Juan Merchan, the judge. They say, all right, Trump is charged with 34 counts of falsifying business records in the first degree. And if you're just joining us on this trial, remember it's 34 counts, but it's basically, they're all document crimes. So like, I forget exact specifics, but Cohen sends Trump an invoice, right? So you have an invoice, that's one line item, all right? So that's one. Then Trump writes a check. Okay, so that's two. Then there's a bookkeeping entry, and then that's three. And then someone else, reconciles the account, whatever. There's another entry after the check is cashed, whatever. And, that's entry 4, false entry, whatever. So all this, right? It's like 4 charges for every transaction. So an invoice, check, the bookkeeping entry, and, reconciliation after the fact. Once, it's cashed and bookkeeper says this is paid, whatever, close it out. So, and the check is like the creation of the forged document. So it's like a bookkeeping entry, the creation of the check, whatever it is, right? Times however many charges. So like times a year, 9 months, whatever it was. He skipped a month for payments, whatever. But every single transaction, this is stuff you normally do. You just pay an invoice for a lawyer, right? A lawyer sends you a bill, you pay it. Both people put it on their entries. You talk to somebody about it, you approve it. All that's fraudulent pursuit. So it's falsifying business records, right? Every one of those was a business record, every entry in the ledger. Now the meaning they make it sound like this is a monstrous thing. It's like this dude just got an invoice and wrote a check. That's what happened. So the charges arrived from allegations that Trump attempted to conceal an illegal scheme to influence the presidential election with this, Stormy Daniels money. An illegal scheme to influence. Now, specifically, Bragg claims that Trump directed Michael Cohen, who worked for his company, to pay $130,000 to an adult film actress shortly before the election to stop her from publicizing an alleged encounter with Trump. Now, Trump then reimbursed the attorney for the payments through a series of checks and caused the business records associated with the repayments to be falsified to conceal his criminal conduct. And I really would have liked, an alleged on that one. It's very kind of conclusive. Judge is already saying, I kind of did this stuff. Every now and then we get kind of an alleged tucked in there. Arises from allegations, right? We want to be clear about this. Now, trial on this matter is scheduled to commence on March 25th, just a short time from here. It's happening right around the corner. Criminal trial, 34 felonies. Now we have the people filed the instant motion for a protective order. This is Bragg, seeking 3 forms of relief. First, talking about the jurors. The people of this court ask this court to restrict the disclosure of the business or the residential address of any juror who's come in here. Second, they ask this court to invoke its inherent authority to prohibit the disclosure of the juror names other than to parties in counsel. And they want to ask this court, Judge Juan, to explicitly give notice to Trump. Like they want to lecture, okay? That's what this is. Can you please lecture him that any harassing or disruptive conduct that threatens the safety or the integrity of the jury may result in forfeiture of access to juror names? So if he starts talking, garbage on the jurors, they're going to say, that's it. Your privileges are released. And Judge, because Trump's like, a child, we need you to go scold him right now. So Trump filed a response. He sent that back on March 4th. He actually consents to the first 2 requests. He says, yeah, no problem. We don't really care about their names or addresses, and we don't really care if the public has them or not either. That's fine. Specifically, Trump says he does believe that a protective order is appropriate. Yeah, that's fine. Now, regarding the people's second requests, he said, and the second request was prohibit the disclosure of juror names other than to parties in counsel. So Trump agrees with number 1. Number 1 says, don't give their addresses out. He says, no problem, happy to do that. Number 2, what about disclosing their names? He says, well, the order should be expanded to also include the individuals employed by counsel of record, right? So not just the lawyers, but also our team, also people who are on our staff. We've got interns who are working here, paralegals, jury consultants, all that stuff. Just broaden it out a little bit. We're fine. They also asked this court to take precautions to minimize prejudice to Trump, such as by not notifying jurors of the existence of protective measures unless the jurors make an inquiry, and then provide neutral explanations for the procedures. So when the jurors say, ask questions about this, don't tell them that we have to protect you because Trump is a dangerous man. Like, well, why? How come this is anonymous and this is anonymous and I can't do this? I thought it was this way. When they ask those questions, just say, well, this is just how we decided to do it for this trial. It's a new COVID, whatever. Come up with some reason for it. But you don't tell them, well, that's because we think Trump's going to get you killed. They're like, what? Trump's going to get me killed? Perfect. I'm going to go rule against this guy. These are people who are oftentimes totally, non-political, apolitical, kind of just removed from a lot of this. So he says, okay, if you're going to do that, just make sure there's a neutral explanation for the procedures, no problem. And finally, Trump asks this court to reject Bragg's request. So now we get some conflict. Reject the request that it provide notice to the defendant that engaging in certain conduct could result in the loss of his statutory right. The law there says that he has a right to access the names. So don't give him the lecture. And so this is the judge writing, Judge Juan Mercan. He gives us some background. He says, all right, well, here's the law. It says the law says that the court can, with good cause, make some changes to these rules. And if we think that there might be jury tampering or physical injury of the jurors or harassment of the jurors, I can make some modifications. Now, although the parties here disagree as to the basis for the order, they do agree a protective order is appropriate. So Trump says, look, I'm not harassing anybody, okay? We're not conceding that for a second. But sure, this is a big public case, and a lot of people might, maybe Antifa is going to come harass these people. Maybe other organizations will that are on the lefty side. So we'll leave them up. Sure, we'll protect them, no problem. Now, having considered the arguments advanced by the people in their motion and by Trump in his response, this court concurs a protective order is good. And the court further finds good cause on the record before it that, here, look at this, that there is a likelihood of bribery, jury tampering, and of physical injury and harassment of the jurors, right? That's a little bit, I think, a poke in the eyeball to Trump. Who's bribing jurors out there? Like Trump's going to go bribe the jurors or jury tamper all these people? In other words, the judge is saying, look, they disagreed about why we need these jurors, but I do find that there's a substantial likelihood of bribery, jury tampering, or physical injury or harassment of the jurors. I think you just tuck those in, okay? Like this would have been enough, the physical injury, because you don't know really where that's coming from. This is a criminal case. So the idea is that the prosecutors are not jury tampering, right? The presumption is that they're not the ones doing the bribing. They're not the ones doing the tampering. So who's the only one left if it's Trump and Bragg? It's Trump. So there's a likelihood of bribery or jury tampering. Like, in other words, the judge could have left that off, right? He could have said there's a likelihood of physical injury and harassment. Maybe there is harassment. It's a big case. A lot of different, levels of wellness in our country. People send letters in and people, look people up and, things get bad. So sure, protect them. But bribery and jury tampering is a justification. Get out of here. So the second request, they say, okay, protective orders in place, no addresses, no businesses, and I'm fine with that. Okay, that's not a big deal. Sure. Why do you need their addresses? But you might want their names, right? Because maybe you want to look up who they are. And maybe that person has a long history when they sit there in court. Like we saw this in the Derek Chauvin case. Jurors are a little dishonest about what their backgrounds are, what their involvement in politics are. Did you ever attend a George Floyd rally? No, never have. No, never have. Weird. Chauvin gets convicted. We see later, you did. So stuff like that happens all the time. And the power of the internet, of course, can bring down some serious scrutiny upon whatever needs to be scrutinized. And so you can see why that might be a little problematic. So they protect that. Now, second request about stopping the disclosure of names to the public. So not only their addresses, but now their names. Both parties also agree, Trump and Bragg, that there needs to be a protective order preventing and prohibiting the disclosure of the juror names other than to parties and counsels. That's us. Trump also consents and asked this court to expand the disclosure of names to other consultants. Now, the court has examined Bragg's motion and together with the accompanying exhibit in support of this protective order, and I find their arguments compelling. For example, they say that Trump has an extensive history of publicly and repeatedly attacking trial jurors and grand jurors. What? People's motion at 2 to 5, exhibits 1 through 9. The motions, affirmations, and exhibits of the respective parties are incorporated by reference here. And I don't think those are here in this filing. So they're saying Trump is attacking jurors, and they probably have a bunch of tweets and stuff in there. We'll see what that looks like. But my recollection is that most of Trump's criticisms have been towards the judges and the prosecutors, not the jurors. So we'll see. Now they continue. So the judge is just, all right, yeah, Trump is harassing. He's going to be the one responsible for this. It's not crazy people, who happen to just be unwell. It's like Trump is orchestrating this. It's that he speaks and he causes that stochastic terrorism to happen against everyone, right? We've seen this with Chutkan. Now, therefore, this court agrees with the parties and finds good cause exists for the issuance of a protective order and prohibiting the disclosure other than to the parties and to counsel. So other consultants will not get it. Now, further, this court adopts defendant's request and it does expand it to those including staff and consultants. So a little strangely worded there, but Trump gets it, lawyers get it, and third parties who are connected to the defense get it. Now, as also requested by Trump, this court will take reasonable precautions to minimize any potential prejudice to either party, except when you're running for an election and you have to sit there for 6 weeks. The precautions may include not disclosing the existence of protective measures unless absolutely necessary to allay juror concerns and providing neutral explanations. So Trump wins on that one too. To be clear, now the parties have not requested, and thus this court has not agreed to close the courtroom during jury selection or at any other time during the proceedings. Access to the courtroom by the public and the press will not be tempered in any way as a result of these protective measures. And an open question that I still have not found the answer to is whether this is going to be televised or not, whether the media will have a pool feed and we'll see what's happening inside. Now, the third request, which is about the lecture. So Alvin Bragg wants Trump to be lectured, and they said, okay, now the court will rule on their third request when it addresses a separate motion. This is about restricting Trump's extrajudicial statements. They said it's sufficient right now here to remind Trump and all parties to this action, including counsel. Now the judge put this in italics. Whoa. So he must mean serious business. Thanks, Judge. And all parties to this action, including counsel, of this court's prior instructions. So he's saying that maybe he'll give him a lecture later, but he's definitely going to give him a lecture now. You see how that works? I'll hold off on ruling whether you're going to get a lecture, but let me give him the old lecture that I already gave him. I gave prior instructions, right? He says April 4th, March 4th, and May 23rd. And watch what this judge does. Let's read it. He says, at the defendant's arraignment, okay, when Trump came here for court date number 1, this court asked counsel for both parties. And the judge is like quoting himself, I think, which is fun, right? He's like, I'm so good. Watch me just quote myself. I love myself. Here, let me quote myself on 4 days, 3 days, multiple days. He's like, wow, I did such a good job on that arraignment. Here's what he said on April 4th last year. Please speak to your witnesses. Defense counsel, that's Trump's lawyer, speak to your client and anybody else you need to, and remind them to please refrain from making statements that are likely to incite violence or civil unrest. What on earth? You okay? Yeah, stop making statements that are likely to incite violence or civil unrest. What are you talking about? Please refrain from making comments or engaging in conduct that has the potential to incite violence, create civil unrest, or jeopardize the safety or well-being of any individual. Also, please do not engage in words or conduct which jeopardizes the rule of law, particularly as it applies to those proceedings in this courtroom. All right, so we have totally subjective standards. No one knows what that means. First of all, you have the First Amendment, okay? So I don't know what, and he's going to say that's all hobbled and limited by your criminal courtroom proceedings, which I would say, no, sorry about that. First Amendment comes first. It's highest priority. One of the key defenses to a corrupt criminal justice system, like the one we're observing and witnessing here in multiple jurisdictions in this country, is your free speech. You have to be able to talk about the hack partisan prosecution that's coming against you so that people can know about it, be disgusted about it like we are, be energized and rally to the cause in defense of that person. So when they gag you, when this judge comes out and says a bunch of garbage like this, making statements that are likely to incite violence or civil unrest, like what? This prosecution is illegitimate? Can he say that? That Michael Cohen is a liar, convicted perjurer, someone who lied again in court in New York just a week ago, whenever that was? Please refrain from making statements. This is like insulting. So here, he says it again. He loved that though. He's like, man, good job. So he practices it, probably in the mirror. He goes there April 4th. He practices it. Or actually, April 4th was the first time. He probably has a similar speech. Let's see what he said next time. He said, Mr. Trump, you obviously have the right to be present at every stage, and that is obviously a very, very important right because it allows you to assist your attorneys in their defense of you. Yeah, it's very important to also get him off the campaign trail for 6 to 8 weeks, right? That's part of the nice, important right. You got to be present. Now, it allows them to consult with you in their defense of you. Now, I think it's definitely advantageous to have the jurors, if there is a jury, to see you present. Absolutely true. And that is a true fact, right? Like if your defendant is not in the courtroom in their criminal trial, the jurors looking around going, okay, this guy doesn't care about his future. Why should I? So for all those reasons, I'm sure you can appreciate that the right to be present at your trial and your proceedings is important. And I'm required by law to inform you that there are ways you can waive your right to be present. But specifically, I would like to refer to 2 specific areas. You can waive your right to be present if you voluntarily absent yourself from the proceedings. So if it's determined at some point down the road that you're not present at some stage because you chose not to be present, I do have authority to find you voluntarily waived your right to be present and to continue the proceedings in your absence. Mr. Trump, do you understand that? Yes, I do. A second way you can lose your right to be present or waive your right is to become disruptive, right? If you become disruptive to such a degree that it affects my ability to preside over this case, I do have the authority to remove you from the courtroom and continue in your absence. Do you understand that? I do. Transcript continues. Now, I have to apply the law. This is the judge as I see it. In that regard, I'm bending over backwards. Yeah, right. And straining to make sure that Trump is given every opportunity possible to advance his candidacy. Yeah. And to be able to speak in furtherance of his candidacy. But with that comes responsibility. That his words, especially when used in the form of rhetoric, can have consequences. Therefore, I am not going to do anything with respect to this protective order or anywhere else to infringe on your client's First Amendment rights. Nor am I going to do anything to limit his ability to offer views on the case, to speak on his experience with the case. He is certainly free to do that. He's also free to speak on the vast majority of the evidence because the vast majority came from the defense, and the protective order does not apply to the evidence that was produced to the people by the defense. So the protective order applies to only that evidence which the Bragg people themselves have obtained and generated and garnered, and I think that's pretty narrow. So in other words, like the Cohen documents and all the business records, all those, the check stub, the entry, the bookkeeping, all the records, all that was really Trump records. She's like, they're yours essentially, so do what you want. It says, I think that's pretty narrow. I'm trying to do everything I can to be as narrow and focused as I can be here, and I think if I were to sign a protective order, at least that paragraph as written, there is nothing there that would prevent your client from being able to not only speak about the case and speak out in his defense, but also to speak powerfully and persuasively without the need to start attacking individuals, disclosing names, addresses, cell phones, identities, or on those lines. That's just not necessary to advance his candidacy. He says, yeah, we agree with that. Trump's lawyer. Okay, yeah, we don't need to disclose names and stuff. That's fine. Thanks for the talk. Another hearing, May 4th. Now, Mr. Trump, there are a couple of reasons why we're having this hearing today. Primarily, we want to go over the protective order. On May 8th, Mr. Trump, I was given a copy of the protective order that incorporated my rulings and incorporated the agreements that the parties had come to. That is the protective order I signed. Now, Mr. Trump, do you have a copy of that protective order? Trump says, yes, I do. And Trump's lawyer, Mr. Blanche, have you had an opportunity to review the protective order with your client? Yes, Your Honor, I have. And have you reviewed each of the 9 so ordered paragraphs that are contained inside that protective order? I have, Your Honor, and I've discussed it at length as well. Were there any issues that your client comes into today's hearing not understanding? Does your child client Trump know? Or any outstanding issues that he would like to resolve at this time? Trump's attorney says nothing to resolve, Your Honor. Certainly our objection that we have noted in our papers. Mr. Trump is concerned that his First Amendment rights are being violated by this protective order. I have explained to him that that is not Your Honor's intention, and that you have made clear previously that that is not your intention, and that this is not a gag order, and that he is free to speak about the case and to defend himself subject to the limitations in the protective order. Judge says, yes, that's true. It's certainly not a gag order, and it's certainly not my intention to in any way impede Mr. Trump's ability to campaign for the presidency of the United States. He's certainly free to deny the charges. He's free to defend himself against the charges. He's free to campaign. He's free to do just about anything that does not violate the specific terms of this protective order. Trump's attorney says, I agree with you, Your Honor. I do not believe it's necessary to go line by line through this. Now, did you also explain to your client, Mr. Trump, that this order constitutes a mandate of this court? Yes, I did. And did you explain to him what that means? Yes, Your Honor. Yes, he understands that he has to comply with the order, and if he doesn't do so, he's violating Your Honor's court order. Yeah, he gets it. And a violation of a court mandate, he's looking at Trump, could result in sanctions. There are a wide range of sanctions, too. They could include up to a finding of contempt. And you can explain that to your client. Todd says, okay, understood, Your Honor. I got it. So then he comes back and he says, so given the fact that I already told him 4 times and explained out this myself, copy and paste my transcript. He's like, I love what I did there. Great work. Fabulous job. So he says, therefore, with all of this that he just regurgitates for us, he says it is hereby ordered that the people Bragg's motion for a protective order restricting disclosure of the business or the residential address or any other prospective or sworn juror is granted. So it can go other than to counsel of record, and it is further granted to prohibit disclosure to those other than counsel, but modified as Trump requested. Staff and consultants are okay. Also ordered that they shall jointly submit to this court no later than Friday, 1 week from today, neutral explanations so that the jurors know that this is not because Trump is a maniac who wants everybody dead, as Alvin Bragg says, or this judge thinks. If the parties are unable to agree on the language of the proposals, then each party is to submit a separate proposal and so on. Then clerk of the court's going to take further action, and it's also ordered that a decision on the motion for explicit notice to Trump that any harassing or disruptive conduct that threatens the integrity of this proceeding is reserved. All right, so this judge is just like, I'm going to save my lecture for later, all right, pending the decision of my other motion about restricting his extrajudicial statements. So in the interim, Trump, and again, italicized, man, he's not as bad as Fannie Willis. That's not caps, okay? Like one alteration is fine, okay? Either bold it, underline it, italicize it, or capitalize it. But don't do all 4 of them at the same time, all right? Relax. You're going crazy. But, you know, that's Fannie land. This is just regular old Mercan. So he says all parties to this action, including counsel, are reminded of this court's prior instructions. Behave yourself. Remember what I said on April 4th, March 4th, and May. This is my decision. Judge Juan Mercan. Out there in New York, and my friends, trial is right around the corner, March 25th, and it's all coming soon. Multiple felony charges in New York, criminal trial afoot. And so we're going to be covering this one at length. Thank you for subscribing and joining us as we do. There's going to be a lot to cover here. And if you want to get the calendar dates on your calendar of the trial, you can go to robertgovea.com/calendar. You can see the Alvin Bragg trial. This is what it looks like. They're blocking out about 6 to 8 weeks for this thing. So in trial, Trump will be there in trial. All of this purple, every one of these weeks are trial days as far as we know. So we're going to be covering it, my friends. Thanks for joining us. Links in the description below. We'll see you back here on the next one.